Thanks once again, Nigel. And we are at this last roundtable discussion 4, that looks at the intersections of privacy and security. I would say that for the most part, we had a lot of very impactful recurrent themes that we'll discuss this morning. We heard earlier on from Dan as he spoke about the need to address at policy those sort of facilities whereby you have cooperation, you have collaboration with organizations, with law enforcement. And in the discussion, we would have raised, for instance, the development of the second protocol to the Budapest Convention that seeks to address specifically that very issue at a global level. We spoke about, I like the analogy that Sherlyn just gave about a CSIRT being a fire brigade, that whereas it's nice to have a fire brigade, it's also good not to see the fire brigade, because we should be focusing on how do we secure before the fact our assets and our infrastructure. And I really take to heart as well Sean's comment on the creation of safe spaces and increasing awareness. And that's really how you can troubleshoot. You can share in confidence when incidents do happen. We all know that reputational risk is very real, and especially in small societies, but being able to share in confidence when incidents do happen and build on those lessons so that we can mitigate or reduce the incidents of the future, that's very important for all of us. So on the question of awareness, we're going to shift focus slightly on this thing about intersections of privacy and security. And Nigel had spoken earlier, he brought up what I will say is one of those age-old debates as to whether one has to be done to the detriment of the other. I believe that the speakers that we have this morning can actually share a new light on that same issue of privacy and security, and looking at it from very specific angles. Our lineup initially had 3 speakers, but unfortunately we are down to 2 because Dr. Jeremy Stevens, our UN expert, he unfortunately can no longer participate with us this morning. But we are flanked with 2 very good experts here. We have Mr. Rishi Maharaj, who is the principal consultant with Privacy Advisory Services. And Rishi is going to look specifically at how we deconstruct privacy in the digital space and how we recalibrate this privacy paradigm, understand how security is implicated. So traditionally, and let me not spoil too much what Rishi may speak about, but traditionally we would have thought of privacy as being within the confines of one's home and issues related to one's physical body. Now that we have very pervasive technologies and now that we have always on devices, we may have to shift a bit the thinking about what privacy actually means from a digital sense. And we also have Dr. Raquel Gatto, who is the General Counsel and Head of Legal at NIC.br. NIC.br is the administrator of the .br CCTLD, and they also deal with the distribution of IPs on behalf of Brazil. And Raquel is going to share with us a bit of her experience related to this issue. So the issue is security and statecraft, online safety and implications for citizens' rights. And just in the event that you may not be aware, Brazil undertook a couple of years ago a very significant exercise in creating something called the Marco Civil, which deals with reinforcing rights in a digital space. So not just talking about sanctions and penalties, but how do you reinforce, what are these rights and how are they reinforced in the digital space? So without further ado, I will hand over the space to Rishi, who will make his intervention.
Hi, good morning, everyone. I hope you can hear me clearly. Yes? So, yeah, in speaking with Kevon, he gave me a very interesting topic to discuss, which is deconstructing the whole idea of personal data and privacy, particularly in the era that we are living in today. Now, traditionally, when people think about data protection, think about privacy, the most important things that they think about are, information that is normally pertinent to you. Your name, your address, identification numbers, your identification number like passport, credit card information, and how do we keep that information secure? How do we keep that information from getting into anybody's hands that we don't want to get into? I think, at least over the last decade, that conversation has shifted a lot away from just looking at primarily data that you have into data that you may not readily give, or data that's collected on you from different assets. And that data has now become very valuable in the way that we live in. We know that technology has advanced significantly over the last decade, especially with the whole advent of artificial intelligence, machine learning. And with that, companies now out there in the private realm and even within the government realm collect a significant amount of data on us. From a government side, I would normally say that government knows everything about you from the day you're born till the day you die and everything that's in between. But we're now seeing where, because of the advent of technology, because of the advent of the Internet of Things, and we have devices that are now continually connected to the internet. A lot of people have Google Home, Alexa, their phones are always on, then their car is also connected to the internet. There's a lot of information that is out there now that is circulating about us within this realm. We also, generally in our normal day-to-day practice, divulge a lot of information about us, both knowingly and unknowingly. So when we go on to the Facebook, social media, LinkedIn, TikTok, whatever it may be, the information that we normally put out about us, but also, although we may not knowingly put out certain information about us, we may put pictures or tag certain images, or even our IP addresses are now open and out there. So that data has now become very valuable. So it's no longer about the information that you know or who you are, but information about things that you would normally, those bits and bytes, pieces of information that you normally wouldn't think are pertinent. And those informations are now being utilized in a very high-mannered way with technology to be able to create and craft an image about who you are as a person, what your likes, what your dislikes. Generally, and this is where we have the whole advent now of data protection, and the way that data protection has begun to redefine the definition of what is personal data. So if I look at it from the most well-known data protection regulation or law that's out there on the books right now, which is the General Data Protection Regulation, or GDPR, when you look at the definition of personal data in the GDPR, it goes just beyond the intentional PII, or personally identifiable information, that most people know about. It goes about information that may, if combined with other pieces of information, can be used to create an image of who you are and what you are not. In the data protection landscape, there's one famous story that everybody talks about, that if you're familiar with it, would be the whole idea of Target. And because of the kinds of information at Target, which is a US-based store, franchise chain, because of the kinds of information that Target generally collects, it has been advocated, whether true or not, that Targets collect so much information about you that they can actually tell when somebody is pregnant even before they even know they are pregnant. So it goes to understanding that kinds of information that we collect, that is bits and bytes piece of information, your geo, your IP address, your location indicator. You know, you have devices that are on all the time in your home that are listening and collecting pieces and bytes of information. We saw, I think, a couple of years back where Amazon actually admitted that Alexa collects a lot of information besides when it's automatically on, when it's just in that stagnant, silent mode. So information is all over and all being collected about us. We have your car, for example. When you go onto your car and you log on to WhatsApp or to Google Maps, or even if your car has a sat nav in it, that car is now connected to other infrastructure that's collecting different information about you, trips that you have made, how long you would have spent at certain locations. We talk about Tesla, for example, and Tesla being a car company. But if you think about it realistically, Tesla is more a data company than a car company. Yes, they're selling electronic cars, which is good for the environment, and we're talking about the whole idea of moving to e-cars. But the kind of infrastructure and data that is built into a Tesla vehicle It's more of a data company than anything else. And this is where we have the intersection of security. And how do we now secure personal data or data that we normally would give out or normally would be collected on us in this environment? I just recently, in the conversation before this, we had the speaker speaking about cybersecurity and breaches and information and how companies treat with cybersecurity incidents. And that's something that data protection laws try to address in a different way. We need to think about it and move away from the traditional realm of security, which talks about the triad of confidentiality, integrity, and availability of data, to why do I need to collect that data in the first place? And those are the kinds of questions that data protection laws ask of people. What data do I collect? Why do I need to collect it? We have principles such as data minimization, privacy limitations. What is the information, what are the data sets am I collecting generally from customers, from clients, in any interaction I may have with them, either online or in a physical interaction? Do I need to collect so much pieces of information? Once I've collected that piece of information, how is that information now utilized within my organization? Companies and organizations need to move away. I'm sure a lot of companies, especially in the financial services sector, are aware of the acronym KYC, or Know Your Customer, which is done to facilitate areas such as money laundering and financing of terrorists. Well, organizations in the realm of data that we are living in right now also need to adopt a different acronym, which I would call KYD. You know your data. You need to know everything about your data, because that data has now become an asset within the organization. Not only the personal data, but the other pieces of information that may accompany that data that may be linked to an individual. A lot of customers are now asking for personalized services, personalized information, or personal ways that you can create products and services that are customized to their needs. And in doing that, obviously, with algorithms and AI, we are now able to do that in a quicker, faster manner. But doing that means you're processing and processing a lot of data. So know your data, ask questions such as, what data are we collecting? Why are we collecting that data? Who uses that data within our organization? Do we need to collect all that pieces of information? How long do we retain that data? Most organizations normally would, generally you keep data until ad infinitum, when either the service is done or after a while you realize 20, 30 years after the fact the data is gone. So again, the whole realm of understanding that data security and cybersecurity, data protection, they go hand in hand. I normally tell people that I work with and speak to that data protection, cybersecurity are like brothers and sisters. They need to work together. But whereas cybersecurity treats with it after the fact, once you've collected the data protection forces us to think in a different way, in a different realm. Before the information is collected, you need to understand everything that goes on in between. And just to raise a point of the interesting conversation that happened before, the whole question of breaches and companies not wanting to report breaches, we are now seeing in data protection laws that have been passed, particularly here in the region. So if we look at, for example, Jamaica, which has their Data Protection Act that was recently proclaimed and has a 2-year period for implementation, and Barbados, both of which have adopted a general data protection GDPR EU model. Both of those laws talks about data breaches that affect personal data and reporting obligation by data controllers. So what those two laws talk about is that once you have suffered a breach, and the breach is of a significant risk to individuals based on the type of data that may have been exposed, the nature of the incident, you now have to report that incident to the regulator within a stipulated time frame. And I think both laws talk about you have to report it within 72 hours or 3 days. And then both laws talk about that you also have to notify your data subjects or the people who may have been impacted by it. So we're seeing here where now there's an intersection happening between data security, cybersecurity, and data protection, where they need to work hand in hand and work together to be able to navigate this whole question of security and data. Because the reality is that people are now becoming more concerned about their information. They're becoming more concerned about the types of information that's collected by them. They're now becoming more concerned about the reputation of the information that may be exposed out there. Just recently, we had examples of error posts, I believe it was, that affected several countries within the region. I think I know of 2 people personally who were affected by that. And then we had within Trinidad the whole question of Massey that had an incident that eventually they've been put out a notice on. So again, we see now with data protection and privacy and type of personal data that you are collecting now has to work hand in hand with your cybersecurity plan, your CERT team, your CISO, and everyone in place, because the game has changed, and we need to be aware of and manage the way that we attract personal data within this landscape. So that's just my opening segment for now, and I pass back over to you, Kevon.
Okay, thank you very much, Rishi. Thank you for highlighting what are those very clear imperatives of data protection, and especially explaining how it's now, well, I shouldn't say it's now, but it's very much married with what would be data security and cybersecurity questions. I have a couple of questions, but I will defer them to after the next intervention. So I'd like to call now on Raquel, who will speak a bit more about security and statecraft, the online safety and citizens' rights online, based on the Brazilian experience. Raquel?
Thank you very much, Kevin. Can you hear me?
Yes, we can hear you.
Yes. Okay, perfect. Thank you so much, Kevin, first for the invitation and for the opportunity to share a little bit about the Brazilian experience with you in this important event. And it's so nice to see some old friends and some new faces. So thank you very much. So just to start and pick up with Mr. Rishi, who was talking about the data protection law. And I'm in particular now going to speak about the Marco Civil of the Internet. It's the Brazilian Internet Bill of Rights, or the civil framework for the user's rights, depending on how you want to translate. But that's basically the innovative processes that we took over the years in terms of building this legislation that really focus on protecting the users. Of course, there is a lot of data protection there. There is also a specific law that is more recent. But I wanted to start just by saying that Brazil might claim that they are one of the first to have this kind of Internet Bill of Rights, but you should know that we were probably the last in Latin America to have a data protection law. So this is all related when we think about regulation and how we keep up with the technology, with the internet regulation and so on. I think there is no competition here. It's not exactly a product deliver or a competitive market, but it's all about the journey that you take and how you understand the societal needs for this piece of regulation. And of course, each country has its own kind of legal framework to comply with, right? Some are more of the civil regimes, some are more of the common regimes based on jurisprudence, and this all needs to be adaptable. This all need to be adjusted to the reality to really work. So that's my initial pitch to connect a little bit on the experience. But then what I'm going to talk today and walking you through this experience, I was planning to go into 4 dimensions. So giving you a little bit of the context back to the the year 2000 when it all started with the problems, of course. So it's a little bit of the storytelling on the context on how the Marco Civil was born, or the idea of the Marco Civil was born, and then to walk you through the methodology, or the how it was built. There is a whole process to share about it in terms of consultations and really bringing the voices that are affected in this piece of regulation. Then to share the what, right? What is in there that is protecting users, how the choices were made, and I probably cannot bring everything, but I picked at least 3 of the major pieces in the Marco Civil that I want to share. And then if we have time, we can talk a little bit more about the future, but I'm sure Kevin will have questions about it later, so we can exchange more. So in terms of the context, it always started back in around 2007. It's really, we all have those celebrities, right? TV celebrities. Nowadays, it's more digital influencer celebrities. And with them, we also have the paparazzi and the curiosity to share their lives. Well, the problem in Brazil really got into the news when one of those celebrities there was a video from one of those celebrities in inappropriate behavior in the beach, in a public space. But anyways, it was posted in YouTube, and then it started a lawsuit to take the video down. And the platform replied that they could not comply 100% with this court order because they could not forbid any of the users. They would continually post the video. Even if they take down this one, there would be 10 others in a second. So by the time, of course, technology was different, the spread of the internet was different, and so on. But still, I mean, there was a huge impact when the judge said, well, I think this is an excuse, and you don't want to comply with the court orders, so take down YouTube. It gave the order for the access for the connection providers to take down YouTube. That's when, for us, YouTube was down for almost 48 hours till there was an appeal, and then it was back again. And luckily, it was not the pandemic, right? I think nowadays it would have been a really pushback. But anyway, so at this point, I mean, it's not that discussions were not happening and problems were not happening besides the celebrity thing, but it really took that fuel to the discussions with all the actors involved and with the society about what is the internet that we want, what is allowed in the internet, what we can do, what we cannot do, who is responsible, and if something happens, what can I do, right? Who needs to do something? And all those questions, they started a movement. Well, initially from the Chamber of Deputies, from the legislative power, to create a law, a criminal law, right? So once you have a problem and you try to solve it by, reacting to fear, reacting in a way that you want to control the problem, usually you go more into this overruling. And that's what happened, right? There was a proposal for a bill, for a law that would really bring more sanctions and penalties. But the society pushed back. And the society said, well, but we don't want only to punish. We want to understand what we have in terms of rights. What are our user rights and obligations before even you can be punished for something? And that's how Marco Civil was born. I mean, the idea of Marco Civil was born because it really started this discussion on what are the values we're trying to protect, what are the principles we're trying to safeguard, and how we're going to do it. And so to make this story short, the Marco Civil, then I'm going for the methodology. The whole process is started with the executive power, with the Ministry of Justice, issuing a public consultation around some of the key principles that were suggested by the Brazilian Internet Steering Committee. I'm not going to have time to explain everything about the Brazilian scenario, but if you are interested, you should look out for CGI.br. That's also where I'm a legal advisor, but that's the body responsible for internet recommendations in a multi-stakeholder way. And it's called the Brazilian Internet Steering Committee in a translation, very roughly translation. But CGI has proposed some 10 principles for the use of the internet in Brazil. And around those, the Ministry of Justice started a public consultation to understand how you would break this down, right? What does it mean diversity in the internet? What does it mean accessibility in the internet? What does it mean freedom of expression in the internet? Very often used as versus security, which is a false dichotomy, but those are the questions that were put forward for the society. And then based on the answers, there was a second round now with a draft bill to be commented. Over 3 years, there was about 2,000 contributions online for both public consultations, but also there was an interesting push in this public consultations, because there was a concern not only to reaching out for those that were familiar with the topic and that were online, but also to reach out for those in remote areas or that were affected somehow by the law and by this piece of legislation, but that were not connected, right, to this processes of online public consultations. So there were several events held in major cities, also to gather face-to-face contributions. So with all of those, there was a final draft bill suggested to the legislative. But then Marco Civil was not happening. Why? Well, because there was, of course, some of the trade-offs that you need to discuss. When you are talking about internet user rights, you are also talking, for example, now it's easily understandable about content moderation and the companies and the platforms and content providers and connection providers, access providers, and so on and so forth. And so it was really, really hard to get it a consensus, to get it approved. But then what happened? What changed? Well, you probably remember Snowden happened. So Edward Snowden revelations about the mass surveillance happened, and it brought back to the news. I think Brazil is kind of moved also for the news, but anyway, it brought back to the news the issue around the user's rights, privacy, and data protection, but also about the fear and the control and how we were going to react about it. To make this story short, and Kevon, please help me with time if I'm overspending it. You know, I'm passionate about the topic, but let me just go through some of those important topics before I wrap up. So Snowden happened, and Brazil took really a role in trying to create a positive reaction. Because we were in this processes of discussing Marco Civil, it was easier to bring this forward to the global level and to suggest a global reaction that would reinforce principles and values instead of sanctions and penalties. And that's what happened. That's when NIC Mundial, for example, happened, that really bring this many countries together, but also all stakeholders really together to reinforce what is important in terms of the internet governance, instead of thinking this was, a strike and it's not working, those problems are happening, and then we need to control it. So during NIC Mundial, which was in 2014, Marco Civil was approved and sanctioned. So there we go. There we have the law, and now we need to work with it. So let me tell you just what is in the law that is also important. So first of all, the Marco Civil states that it's founded on the freedom of expression, human rights, on the recognition of the global scale of the network, and on the collaborative efforts. And that's a huge statement in a federal law, in terms of the commitment that it takes for the internet itself. But then, in terms of the user's rights protection, I'm going to highlight three of them that I think are really inspirational. The first one is regarding the access. So it establishes that access is fundamental for the exercise of citizenship. So it really puts the connection, right? The right for people to get connected to the internet and this place of human rights. And that's huge. That's huge in terms of how it allows the other policies within the public policies to really bring this as a priority in Brazil. Then it also took one take on net neutrality. So I don't know how much net neutrality everyone is familiar with, but that was a big debate some years ago. Sometimes it comes back, but it's really about ensuring one of the characteristics of the internet, which is keeping the intelligence in the borders and keeping this middle right without interference, so the internet can work. And there are other concepts, other definitions for net neutrality. For example, just to give you the comparison, Chile, another Latin American neighbor, was one of the first to have net neutrality regulation, but they took the concept around consumer rights. So they are more connected with wherever flows in the internet. You cannot breach, right, the consumer, the equality to access. On the other side, Brazil took into Marco Civil the technical definition, which is wherever flows, and it's a very rough definition, but I can share the law later so you can see it, but it's wherever flows in the internet needs to go, the packages needs to go in a non-discriminatory way. So you are not going to filter or block because of, because of the content or the brand that you are using and so on. So that's basically what also the Marco Civil took in terms of protecting one of the characteristics of the internet. And of course, putting some of the exceptions that are necessary, but those are other, this is a whole other discussion to open. And then finally, the third one I want to bring that Marco Civil also establishes is the intermediary liability. And that's really now one of the waves in terms of regulation, internet regulation. Because, back in 2014 or in this discussions, tools were different, applications were different that we were using, but it's still, there was this protection in terms of the focus for freedom of expression. So you should be allowed to do things in the internet without being controlled or without asking for permission. But there are some things that you need to be liable with only if you were the one who posted it, for example, who gave, who made the act to it, or if by knowing it happened, you didn't do anything, right? So it really helped in terms of when a problem happens in the internet, right? Some discrimination, some harmful content happens in the internet, on the internet. It's hard to know where to start who is responsible? Is the one who allocated the IP address, is LACNIC or ARI? If there is a website, is it NIC.br, the CCTFD, the .com, or whoever? Is it the platform, right? If you're talking about being at Facebook, or is it Google as a search engine? Who is responsible, right? It's very hard to know. Or my telco, the one who brings the internet to my home. And so Marco Civil stated precisely that for example, the connection provider, the provider that brings the internet to your home, is not responsible for the content over the internet. It's really stating also one of the characteristics of the internet that Shannon was talking, the internet way of networking. And then there was also the protection in terms of the content providers. So let's Facebook and Instagram and others, in terms of they would only be liable if they receive a court order and they don't do anything about this harmful content. So basically it made this clear on who is responsible when those things happen in a very simplified way. Okay, so one of the things we learned also during the discussions of Marco Civil is that we cannot tackle everything. It's impossible to tackle everything because technologies change, but also there are different ways to approach different problems. And so two things were fundamental for the Marco Civil. One thing is it tried to bring more to the let's say higher level, or to the big picture, to the principles ways, to the values ways. So it didn't go into the operational way as much as it was possible, and left to the other rulings and executive orders to define more of the operational and the how, because then you don't need to change a federal law. And this was really, really important. And the second one was to separate some of the discussions that were more dense and more complex, like data protection. So this is mentioned as part of the principles and the values, and there are provisions in the Marco Civil, but then there was a whole new law in 2018 about the general data protection in terms of like GDPR in Europe and so on. So anyway, that's the kind of the brief about the Marco Civil. And just to give you this, in terms of the future, as I said, this is a journey, this is not a product delivered. Marco Civil is still tested today in terms of its interpretation with the judiciary, in terms of its applicability, and also in terms of the evolution of some of those applications. For example, WhatsApp and Telegram and those messaging apps were not thought of, right, in terms of when Marco Civil was built, and there are some particularities that are not taken into the intermediary liability ruling. And so those are some of the changes that might foresee in Marco Civil. But still, it's really a piece of legislation that is helping to bring more of this user protection and this user rights forward. And then you go to discuss the sanctions and penalties that are also important, and we can talk about it later. So Kevin, back to you, and I'm sorry if I crossed the time.
Thank you, Raquel. No, you didn't cross the time at all. I think that you really gave us a very insightful look at the precursor of what we would have heard about in terms of the Marco Civil. I really liked how you emphasized that there were these very core discussions on principles and values, and you saw the commitment of government authorities to not just rely on online consultations, but to go out where people are connected and even take their contributions into consideration in developing this. So I think we got a great appreciation of of what would have been the precursor, the build-up to developing the Marcus Civil, the understanding that it's still a work in progress, the lift that the Snowden revelations would have given it on a global scale. And I really appreciated getting the details on that. I wasn't aware of some of those things. So thank you very much for sharing that. So I have some questions, and I'll also ask that anyone who's connected to please send your questions forward, but I'll take the moderator's prerogative. I want to go back to Rishi a bit. Rishi, I liked how you outlined a couple of things about data that we may not be fully aware of. One of them would have been the question of multi-sided markets. So data is something that an entity that operates on multi-sided markets, and multi-sided markets, for want of a comparison, would be one that operates in social networks, but also operates in what would be online advertising. And based on the regulatory strength or lack of strength in one, they could have a competitive advantage in the other, right? And we would see that global standards such as the GDPR try to attenuate, try to stymie, not stymie, but put a bit more control as to what will be these flows of data, and really reinforce from a European value perspective the importance or the primacy of rights. So Rishi, in a Caribbean space, from a Caribbean perspective, do you think that the discussions on data protection are more so rights-based, or should they be more rights-based? Or do you think that there may be Caribbean stakeholders that are much more interested in the monetization and the capitalization of data? I mean, you hear this cliche in a lot of technology forums: data is the new oil. Where exactly do we find ourselves from a Caribbean perspective in our approach to protecting data? To what extent should we be inspired by European standards? Should we adopt that as global standards, or are we somewhere in the middle if we probably have some more economic interests in mind?
That's a very good question. I think it's both ways. One, it's a lot of companies right now taking the approach of wanting to monetize the type of data that they have, and a lot of companies are now employing analytics and algorithms to be able to crunch the data that they have on individuals to make it more personal, to be more predictive in terms of, if you're going to give a loan to X person, what's the chances of that person defaulting on that loan? So so there's an economic side to it, but there's also a human rights side to it. So if I look, for example, let me compare Barbados and Jamaica, for example. So in Barbados, in terms of their laws, their data protection law was passed, that is 100% totally aligned with GDPR in terms of some of the clauses are literally extracted out of the GDPR articles. It seems that Barbados looked at it from more of a monetization point of view, from a business perspective, in terms of Barbados' own thinking of where they want to go ahead. We know, for example, with the metaverse, that Barbados has now taken a jump forward in terms of embracing technology, cryptocurrency. We have Bit in Barbados and other things that are now wanting to drive utilizing technology in a new way for economic stimulation. So I think, and particularly because of the pandemic and the impact on tourism, that is a good way of diversifying the economy away from the tourism sector. So definitely driven by economic base. But then if I compare that, for example, with Jamaica, in terms of Jamaica, when it really standard out as important in Jamaica was more from a human rights perspective. So many of the listeners may know, for example, that Jamaica, the government looked to embark on, and they began to implement a NIDS program, which is the National Identification System, that they passed a law and they began to implement it. And then that particular program was challenged in the courts in Jamaica, and it went all the way up to the Supreme Court in Jamaica. And when you look at the judgment that came out of that ruling, a lot of that judgment was around the whole idea of rights and data protection. and privacy and frameworks, and looking at comparative examples in India, for example, where the India government did a similar type of matter and it went to the courts there. So it was bounded in more of a rights perspective. But so I think from a Caribbean perspective, we need to look at it in both ways. Because if you look at the language that is used in both the Jamaica and Barbados perspective, they utilize the language of not infringing on the rights and freedoms of data subjects. And by the rights, we mean the rights that have been ascribed to them under the respective laws. But in freedoms, you're now bringing a constitutional perspective of looking at the constitutionality of, like Raquel was saying, freedom of speech, freedom of expression, freedom of association, all these different things. So I think in the Caribbean perspective, it's really in between the two of both, looking at it from a rights perspective as well as an economic base.
Thanks, Rishi. And just to piggyback on that, I like how you gave the examples, the Barbados and Jamaican example, the ruling from the Jamaican Supreme Court or High Court on the NIC's deployment. What would you say, and this is where we look at what you would call those intermediate points. So for me, an intermediate point between what could be a very strong rights-based regime and what could be a regime that favors more economic considerations would be that negotiated US-EU privacy shield, correct? If there was some sort of plurilateral arrangement like that for the Caribbean, what would you say would be the top priorities that the Caribbean needs to understand with a plurilateral arrangement? So on the one hand, I don't know if you can unpack what that US-EU privacy shield is exactly about, and on the other hand, if you could identify like the top 3 factors or conditions that Caribbean policymakers would need to know.
Right. Well, data is a $1 trillion industry, and data flows are a $1 trillion industry. So how the EU has created their legislative framework is that it's a lot extra jurisdictional in terms of it looks at other countries out there and data processors such as your cloud service providers or any other body that you may be using to process your data. So how the EU landscape has been structured is that if I am a company based in, let's say, Ireland, Republic of Ireland, or let's say Germany or France, and I want to employ a cloud service provider, and their cloud service provider is probably based in the US or let's say Argentina, for example. Those are 2 good examples. What does that mean for the transferring of data and the protection of the data in those countries? So what the EU says is that if you're going to export the data outside of EU jurisdiction, then you need to have certain safeguards in place. One, that country must either be part of an adequacy agreement where the EU would have assessed that country and deemed that country to be an adequate port to receive data, so that you can receive data, or there must be some agreement in place between the EU and the US. So Argentina, for example, is an adequate jurisdiction. It was assessed in terms of the landscape, in terms of the laws and protection, to be an adequate landscape for data to be exported to, because they also have a federal or a national data protection law. The US doesn't have a federal data protection law. States may have it, but federally there isn't one. So the US and the EU, because of the trading relationship and the billion-dollar industry, created something called a safe harbor or US privacy shield, which was more or less an agreement that the US FTC, the Federal Trade Commission, put in place that companies in the US would sign up to, basically stating these are the privacy principles or protocols that we are going to follow to be able to adhere to it and that allow for data transfer. That was challenged in the courts. It took about 3-4 years for that to be challenged in the courts. And the decision that came out, I believe it was July of last year, is known as the Schrems II decision, because the decision was challenged by a guy called Max Schrems, who's based in Austria, challenging that whole privacy and that whole rights because of US other laws, such as the FISA laws, National Security Agency laws, the Cloud Act, that allows the government the ability to go in and knock on, let's say, Amazon or Microsoft's door and say, listen, I want to see data that you have on X and Y person for federal purposes and stuff like that. The EU Court of Justice eventually ruled that the privacy shield was inadequate, didn't provide the protection, and they struck it down. So that more or less made it illegal for data transfer between the EU and the US. Obviously now they're working on ways to be able to amend that. There are certain agreements in place and certain discussions are taking place. How that impacts the Caribbean, I think, is because of where we are positioned. We are positioned on the back door of the US. We have a very close relationship with the US. A lot of companies use US jurisdictions to store data because of economies of scale and everything like that. But we also look to transfer to the EU because we still have that legacy system where we are tied to the EU. A lot of countries in the Caribbean, we have Martinique, Guadeloupe that have EU relationships and stuff like that. So I think from a Caribbean point of view, we need to observe these things that are happening there and look at some of the critical things that are important for us in terms of this whole data flow arrangements. We need to think of the critical landscape in terms of securities that we need to put in place to protect those data. We need to look at trade agreements. So for example, a lot of these trade agreements with EU, with Canada, for example, have these protocols that are built into them that saying if you want to transact trade with us, you need to have similar laws on your books. So it's about understanding the reciprocity that these countries are now enacting on Caribbean countries to be able to put in place. Jamaica, Barbados, which are the two new laws on the blocks, talks about data transfers outside the jurisdiction for Barbados and Jamaica nationals. They also have the commissioners the ability to now look at countries and deem them safe points of entry so that you can transfer data with them. So I think that's one thing that we need to look at from a CARICOM perspective, from a business perspective, and from a legislative perspective in terms of how do we navigate these waters of trades, particularly with regards to data flows throughout.
Thanks very much, Rishi. I think you touched on a question. It came up in the chat and on the Q&A, but this was from Angus about the DPA in Jamaica and Barbados, how they will affect data flows from Trinidad. What impact will they possibly have on business? I think there's very much a need for us to discuss within CARICOM the entire question of intra-regional data flows and the specific standards that we want to define as a region. Considering, as you said, we have the US's backdoor, we have elements of EU standards in terms of Martinique, Guadeloupe, French Guiana, and such that are really nearby to us. So it does give us a lot to think about in what could possibly be a Caribbean data protection regime, if I must say, something like that. I'm putting that out there. I know we had that in the past, but thanks very much for that. I just want to give a bit of spotlight to Raquel based on some of the comments she had made about the Marco Civil. So Marco Civil at first addressed the rights of people, and I think that was very great. It also provided a lot of clarification or reduced ambiguity in terms of the roles and responsibilities of internet intermediaries. One of the biggest or more contemporary developments on internet intermediaries and obligations for transparency and accountability comes from the recently thumbs up for the EU's Digital Services Act. Could you just share with us a bit what does that mean in terms of these internet intermediary liabilities and what possible impact that the DSA over there in the EU could have on businesses here within LAC? Rishi touched on the fact that at least when it came to the GDPR, a lot of the EU's laws are very extra jurisdictional. They have form mechanisms to reach beyond their borders by virtue of anyone providing a service to EU citizens. But what are some other possible, what is DSA and what are some possible implications for us here in Latin America and the Caribbean?
Thank you very much, Kevin. Just before I start, I think Nigel had the hands up. I don't know if that's, sorry. No, he puts the hands down. Sorry, Nigel was just, but so let me try to bring this. There is a lot to pack here. Let me try to bring this in a nutshell. In terms of intermediary liability, it's very hard to speak. Imagine myself, who I'm not a native a speaker, English speaker, but that's really in the trend now in terms of it's both, right? To use some of Rishi terms, it's about the user's rights, but it's also about the economic and the market regulation. And so either the Europe with the Digital Services Act, and more recently with the package in agreement with the Digital Market Act, which brings us about 600 pages of regulation to digest, in terms of how we're going to balance the big techs, right? The platforms, the internet applications, and the users' rights. But it's not only restricted to the EU, right? In the US, there is the discussions around Section 230 that also tackles this intermediary liability in terms of what you were responsible for the content online. And let me bring this to a very, very lawyerish approach. Lawyers are trained to see the problems first and the breaches. And so with the overall approach in intermediary liabilities, what concerns me, I'm going to bring the 4 points that really concerns me, either in the DSA or the discussions around the digital, the section, the 230, and in Brazil with the update of the Marco Civil in terms of a new proposed draft bill for regulating content online and fake news. It's called the draft for fake news, actually. But the 4 concerns are, the usual copy and paste style. So, or to a better expression that is more used, there is no one size fits all. So it really concerns me that we're trying to put into a same template everything, and it's not going to work because regulation in each country are different, that's obvious, but also the needs are different, right? And it really depends on other pieces of protection, for example, that you have or not, and to have a comprehensive piece of legislation for the internet and for the user's protection, you really need to go into different dimensions that are not only regulating by technology. And that's my second concern. Most of these approaches are taking the technology as a starting point to start regulating it. And it's also not going to be sustainable because, as I said in the previous pitch, technology changes, but also new technologies arrives. And so you cannot guarantee that a law will be 100% applicable if you only regulate by technology. To give an example, when there was the panel about cybersecurity and two-factor authentication was mentioned, there were pieces of proposed legislation to make it a law, right, about two-factor authentication. You understand the intentions behind it, which are good, but then if you do regulate by this, for example, federal law, imagine if this technology changes and there are breaches to that, and then it's harder to keep up. So anyway, just a silly example to say and connect that you cannot take as a starting point technology back to principles, back to values, and then you go down and escalate down to the operational level on the how. Then in terms of the third, and I'm going to be brief, I know time I'm going over time, but for the third piece that concerns me is also not considering what the internet is and what are the characteristics for the internet. There is this big backlash, right? This really putting all technologies in the same bucket, whether you are a platform, whether you are a connection provider, an access provider, whether you are a CCTLD, and so on. we are all in the same bucket in terms of you are the bad guys, and we need to regulate and control what you are doing because bad things are happening on the internet. So basically, that's the narrative on the fear that will, if you don't push back, will escalate to something that is over-regulating and that can break how the internet works. So that's the third concern. And the fourth one, it might seem pretty obvious, but I need to say it. It's focus on the people, right? We do lose this focus very often when we got into these discussions. But the internet is here to connect people. It's here for the communication among people, while the packages itself go into devices. But it's about the society. And so most of this regulation is really talking about a behavior and problems that are beyond the internet. And so that's also one thing that is pretty clear in some of the DSA and the DMA and the Section 230 discussions that are really missing the focus on the society and behavior and people. So I hope this really answers your question, Kevin.
Great. Yes, thank you so much, Raquel. Unfortunately, we have come to the end, and I'm so appreciative for both of your contributions. I think we had a very enriched discussion. And Raquel, you were not here on the first day, and I know you came in a bit late today, but it's so interesting that some of the points you made are actually recurrent takeaways that we have spoken about, and it really dovetails well with your particular message. Focusing on people is very important in any sort of regulatory landscape. Even when we're thinking about having effective or efficient cybersecurity, people must come first. People are very important to have those robust systems and to actually build out resilience. And even the point that you said about not putting internet in front. So technology neutral language, thinking about what exactly needs to be regulated and to what extent. So trying to focus more about fit for purpose regulation as opposed to over regulating and grouping all of the internet ecosystem as the bad guys. Knowledge about what the ecosystem looks like and breaking that down is very important. And the takeaway that really just impacts me the most is what you said about avoiding these one-size-fits-all approach. We cannot import wholesale developed solutions from the EU or anywhere else where we did not have sight as to what are some of the indigenous inputs and concerns there and expect that to be used in our jurisdiction. So for instance, not the DSA, but the Digital Markets Act has an entire section on obligations that are actually based on pending and past difficult court processes in terms of competition for digital actors, for electronic communication players. So I really like how you really came in at that point and summed up everything and reinforced some of the themes that we've been talking throughout the 2 days of deliberations. And I'd like to thank both of y'all on behalf of all of the organizers for agreeing to participate here. Raquel in particular was a last minute addition based on some challenges that we had. So thank you for your time. I'm very thankful for your time and intervention. Thank you, Rishi, for continuing to show us what we need to know, so continue to shine the light on Caribbean data protection, and look forward to having further discussions with you on platforms like these to continue sharing that info.